This is Community Unity Now, the D Tycoon Show. This is Bill Morton, President of the Rogers Park Chamber of Commerce, and I am Trudy Leong, Administrator of the Rogers Park Chamber of Commerce. Our very special guest is Brianna Payton. Brianna, please tell us all of your qualifications and what you are working on.
Absolutely. So my name is Brianna Payton. I am a Senior Policy Analyst at the Chicago Appleseed Center for Fair Courts, which is a member of the Illinois Network for Pretrial Justice, which has been advocating for the passage of the Pretrial Fairness Act for some years now, and we're really excited to see it go into effect.
Mm-hmm. And Brianna, how many years have you and your coalition been working on the Pretrial Fairness Act?
So the coalition has been working on statewide advocacy since officially January of 2019. But prior to that, there was even Cook County-based advocacy that was going on since May of 2016.
And being a coalition, you have a lot of different organizations involved. What are some of them?
So we have lots of different types of organizations involved in our coalition. We have faith-based organizations such as Trinity United Church of Christ or Faith Coalition for the Common Good. We have policy-based organizations such as Chicago Appleseed Center for Fair Courts. We have organizations that do organizing, community organizing such as the People's Lobby, Rockford Urban Ministries out in Rockford, United Congregations of Metro East out in Metro East. There's just lots and lots of different organizations and types of organizations that have come together to advocate for this work.
Just to give us a basic rundown of what will happen when the Pretrial Fairness Act goes into effect.
When the Pretrial Fairness Act goes into effect, Illinois will be the first state in the country to completely abolish the use of money bond. So that means that whereas in some jurisdictions, and currently in jurisdictions across Illinois, someone can go before a judge if they're accused of any crime, and there can be a price tag put on their freedom where the judge says you can be released so long as you pay this amount of money. Well, once this law takes effect, that will no longer be a legal practice in our state, and judges will have to make more reliable and fair decisions about whether or not anyone should be released before trial.
And how are those decisions different from the decisions that judges have to make now when money bond is still in effect?
So the decisions are different in that under the new system, they will be done with hearings that are much more rigorous. Right now, bond hearings can last anywhere from 3 to 5 minutes, and previously they were as short as 30 seconds on average. Under the new system, each side, the prosecution and the defense, will present their arguments and evidence for why someone should be released or jailed before trial, and the judge will have to consider those arguments and any witnesses that are brought and evidence that's presented and make a final, well, not final because it can be appealed, but a clear decision about whether someone will be released. Under the money bond system, the judge's decision is not clear, and it's a bit of a gamble because the judge is setting a money bond, and so it's a gamble of if they have the money, they can get released, and if they don't have the money, then they can't. So even the judge at the end of that hearing doesn't know whether that person is getting out of jail, and a lot of times neither do they, because it depends on whether they can come up with the money.
So I understand that a judge has to describe how he came to the decision-making process, but he doesn't if there's money bond?
Right, because a money bond is technically and legally, it's a condition of release. So that means that the judge is legally saying that the person can be released as long as they pay money. So with that being a release decision, they don't have to provide the same justification as if they would if they were completely denying someone release.
So how does this make our state more safe? And how does this make it more fair for people who are not convicted?
Well, it makes it more fair because under the current system, you could see two completely different outcomes for people that have the same charges, the same background, the same facts of their case, but different levels of access to wealth. These people could have the same money bond set, and one of them, because they or their family can access the money to pay the bond, can get out and be able to navigate their court case while they are still able to keep their job, their housing, their family intact. And on the other hand, someone who them or their family is not able to access that money will suddenly be thrown into jail and potentially lose their employment, their housing, even custody of their children. And so it will be more fair because now it's going to be the same treatment across the board for everyone. And it will be more safe because it'll be a decision that's taken more seriously. Like I said, when a money bond is set, it's a gamble. You don't even know whether the person is going to stay in or out.
And no justification needs to be made before when there was a
It
money
doesn't
bond.
require the same justification. And so now it'll be more fair because there's a real deliberation and justification required for the decision. And it'll be a decision that is less arbitrary because you actually know the outcome and it won't just be blowing one way or the other based on the amount of money someone has.
So you said that there could be an appeal from by either side.
Yeah.
And then while that appeal is going through, where does the detainee go? Where would the detainee wait until the appeal gets processed?
Well, when someone is appealing a case at any stage, things stay as they are until the appeal is processed and something changes.
Mm-hmm. So that means that the person does not have to remain detained then?
Well, if they are in jail and they're appealing that decision, they will likely have to remain in
Got
jail
it.
until there is a decision on the appeal.
Got it. Okay.
So while we're on that subject, just a little bit, veering off a little bit, do you have any ideas or statistics or numbers as to how many people are detained on a regular basis or annually?
Yeah, across Illinois, there are 250,000 people that cycle through Illinois jail. So that doesn't mean that there's 250,000 people in our jails right now, but in a year, that's how many people are cycling through. Here in Cook County, there are about 5,000 or so people in the jail on a daily basis right now.
And money bail and bail bond are the same thing. And when it goes away, do you believe that the numbers will increase or decrease?
So just to clarify, money bond and bond are not exactly the same because bond just means release. So money bond means that you have to pay money in order to be released. And so we're not abolishing bond or bail because that just means pretrial release, but we're abolishing money bond, money bail. And what was your second question?
Will it positively or negatively impact the numbers of people incarcerated?
It is our hope and it is the intent of the law to dramatically reduce the number of people that are in jail before trial because we believe that there are far too many people in jail who do not pose a risk to any other person, and instead they're there simply because they can't afford to pay the money. And so it's our hope that if the law is properly implemented, that once it is in effect, that those numbers will go down.
For the 250,000 people that cycle through the courts every year, do you know about how many are in Cook County?
In Cook County, I do not know off the top of my head.
That's okay.
Yeah.
So the justifications that you described, could you go into more detail about what justifications the judge has to make in order for release or detainment?
Absolutely. So the judge has to consider three main factors to make their decision about whether someone will be released pre-trial. They have to consider whether the person has committed an offense that is a qualifying offense. There is a set of more serious charges that are eligible to be considered for pretrial incarceration. If a charge is not serious enough under the new law, then they will only be eligible for pretrial conditions or restrictions and requirements, but not pretrial jailing. So first, there must be a charge that is serious enough to qualify for pretrial jailing. Secondly, there must be a threat of harm or a risk of harm to another person or to the community. Or there must be a high risk of willful flight, so a likelihood of fleeing from prosecution and not returning to court, purposefully not returning to court. And then lastly, the judge must find that there's no conditions other than pretrial jailing that can mitigate those risks. So it's one thing to identify that the risk is there, but the judge has other tools at their disposal to mitigate the risk. For example, a judge might order someone to electronic monitoring or to pretrial services, supervision by a pretrial services office. And so those are things that a judge could use rather than sending someone to jail. And so the law requires and the Constitution requires that judges set the least restrictive conditions. So if they're going to throw someone in jail, they have to find that they needed to do that in order to mitigate any risks.
So does that necessarily mean violent cases only, cases of violence, or are there other circumstances that you can give an example of?
Where someone might be incarcerated before trial?
Yes.
It's not that it's limited to violent or only nonviolent, but it's based on whether there is a concern for safety, and there's kind of a number of there's a delineated list of charges that would apply. It is typically that most of the charges that are eligible for pretrial incarceration are those where there was harm or threat of harm to another person.
And you also mentioned willful flight. So if that person is very likely to flee, how do you have any idea how they would determine that? If they have enough money or anything in the past? How
That
would
is
they
a standard
determine?
that's still being developed because that's a new requirement of the law. Previously, they were able to just go off of has the person missed court in the past. But the problem with that standard is people often miss court for reasons that do not have to do with purposefully fleeing prosecution. They might have forgotten they had court. They might have not been able to get off work. They might have not been able to get childcare or transportation. And so when you treat those as though someone has run away from prosecution, then you end up putting people in jail who are not actually running from the law. And so under the new standard, the courts will have to figure out what it looks like to look for willful flight and to not only assess for has someone missed court in the past.
So maybe the representation didn't show up to do the continuance or something along
Well,
those
typically
lines.
it's not the case that it's about counsel or attorneys not showing up. It's about whether the person themselves showed up. And so they will have to figure out a new way to assess for whether someone was purposely fleeing in that situation.
In other words, getting ghosted by a bus and being late.
So even if you're ghosted by your attorney, you still have to show up.
Yes.
Mm-hmm.
And also, there are, you said that they're still developing these, how they're going to be justifying these detainment and release. So how do we, when will we know, and how long does it take for them to develop all these conditions?
Well, it's not that they're still developing how they're going to decide whether someone is detained or not. They have the standards and the judges already have all the tools they need to make those decisions. We just have to wait and see what it looks like in terms of how judges are assessing for willful flight, because that is a standard that's going to be, the law has already made it clear that they need to look for willful flight, but we have to wait and see how they go about doing that.
And then see if there are any changes that need to be made okay. I see that there's going to be some changes in electronic monitoring too as a result of the Pretrial Fairness Act.
Yeah.
Could you describe a little bit to us about that?
Absolutely. So the Pretrial Fairness Act protects the rights of people that are on electronic monitoring. It doesn't establish electronic monitoring. It doesn't expand electronic monitoring. But since electronic monitoring is already in use, at least here in Cook County and some other parts of the state, it puts in standards that must be met in order to protect the rights of people that are on electronic monitoring. So for one, it requires that people on electronic monitoring receive permission to leave their homes at least twice a week, 2 days a week, in order to do things that they need to do to take care of themselves, whether that be going to the grocery store, to the laundromat, to the doctor, or what have you. Prior to the Pretrial Fairness Act, at least here in Cook County, we were observing many cases where people were not being given permission to leave their homes under hardly any circumstances. There were supposed to be systems in place where they could request movement, but it was frequently denied, even for things that people needed to do to take care of themselves. So the law was meant to mitigate against that. That's one thing. Another thing is that the law requires that someone who is on electronic monitoring and on house arrest during the pretrial phase, that they receive credit for that time if they do end up receiving a sentence. Mm-hmm. Another thing that it does is it requires that judges reconsider orders to electronic monitoring every 60 days, because right now, and prior to those reforms, people might be ordered to electronic monitoring and then left on there for months, weeks, years, even if they could have been safely taken off of it. And so it creates a process for reconsidering. And lastly, the Pretrial Fairness Act requires that if someone is going to be charged with escaping from electronic monitoring, that there must be a willful intent or a knowledgeable intent to actually escape, because previously there were situations where someone was charged with escape because of a minor technical, sometimes even accidental violations of electronic monitoring conditions.
And the burden of proof for willful rests on whom?
The burden of proof for escape?
Yeah, for willful flight from electronic monitoring.
So that will rest on prosecution. If they are, the burden of proof, for any crime will always rest on prosecution, because people are innocent until proven guilty. And
right now you say that the electronic monitoring, the stipulations are kind of arbitrary. So who is in charge of the stipulations now?
In Cook County, the electronic monitoring program, one of the larger electronic monitoring program is run by Sheriff Tom Dart, but then there's another electronic monitoring pretrial program that is also run under the Office of the Chief Judge. So we have two programs, in Cook County, and that is a very inefficient way to run that. And so there has been advocacy. The organization that I work at, Chicago Appleseed, has put out a report on electronic monitoring in Cook County, and one of the recommendations is to reduce the size of electronic monitoring programs in Cook County and condense into one.
Right now, if someone wanted to appeal some part of, complain about some part of the electronic monitoring, they probably wouldn't even know where to go.
They might try to complain directly to the supervising authority, such as the sheriff's office, but that doesn't mean that they will have much success. They can also appeal to the judge to be released from electronic monitoring, but that also doesn't mean that they will be successful in that.
So in the future, every 60 days when that comes under review, who is the body that reviews the electronic monitoring?
The judge.
The judge.
And that already is in effect. The electronic monitoring reforms took effect in January of 2022.
Okay. And do you have any data about how that has affected the people that are under electronic monitoring?
More so anecdotal and qualitative data. We've heard reports from people that the requirement that they receive movement a couple times a week has been a game changer for people, that sometimes just being able to step out of your house and get a breath of fresh air, or go take your kids to play outside, or go take your kids to school or attend a graduation. We've heard stories from people on electronic monitoring that those have made a huge difference for them. And we've also heard of cases where the ability to get credit for time spent on electronic monitoring ended up making a big difference for someone. For example, an elderly woman who might have been otherwise sentenced to spend time in jail was able to not have to serve a sentence in jail because of receiving credit for electronic monitoring.
And before they would not receive that credit then?
Right. I believe that it would have been up to the discretion of the judge to whether they wanted to take that into account with the sentence, but now it's legally required.
So with the money bail system, sometimes the money was used for the judgment. Sometimes the money was used for different things. What was the money used for, and how will that change when there is no more money bail?
The money was used for a number of things. In a very small percentage of cases, it went to restitution. In other cases, it went to fines and fees that the court collected. Very little of the money, only about 20% over the last few years, actually went back to the families at the end of the case as promised. So now that money won't be collected, and courts will have to find other ways to balance their budgets and not on the backs of people who are poor and marginalized in our communities.
So how did they use that bail money to balance their budgets exactly?
Well, I don't know. They just used it. They took it, and the families didn't get it back. But how they used it, I mean, you'd have to ask someone who worked in the courts.
That's the question.
And when people did not have to pay bail, they might still be assessed the court fees, and then they will still be owing court fees, like those that appear before court. Is there anything in the Pretrial Fairness Act that addresses court fees?
No, the Pretrial Fairness Act doesn't address court fees outside of the fact that it ends money bond. Although I do believe that under the Pretrial Fairness Act, there is no, like now with the way that electronic monitoring is running, there won't be anyone paying for electronic monitoring in the state. No one was paying for electronic monitoring in Cook County, but it was happening in other parts of the state. And so our understanding is that with the implementation of the Pretrial Fairness Act, no one will be paying to be monitored while they are awaiting trial.
So they had to be billed for it then, and they
in some parts of the state, yeah.
Wow. What else is going to be changing when the Pretrial Fairness Act goes into effect?
So one other thing that will be changing under the Pretrial Fairness Act is the way that alleged violations of conditions of electronic monitoring are handled. So, or not electronic monitoring, but conditions of pretrial release. So when someone is out on pretrial release, they have to promise to, not commit any offenses and return to court. But what would happen is sometimes if someone might have been accused of even a small or minor offense, they might have been thrown back in jail for the rest of their case, which could last months more or even years. Under the Pretrial Fairness Act, there are levels of offenses if someone is out before trial. If there is a minor, petty or low level offense, there may be sanctions that can be imposed, but throwing somebody in jail for the rest of their case is only going to be allowed in cases of serious misdemeanors or felonies.
Could you give us like an example? And then also those sanctions, are you talking about something like tickets? And
So it
fines?
wouldn't be tickets. It could be a verbal admonishment from the judge. It could be a written admonishment from the judge. And it could be even a 30-day sentence to jail, but not, throwing someone in jail for the rest of their case. That would only be an option if it's a Class A misdemeanor or above.
So how has, you said that the electronic monitoring has been in effect for about a year. So do you have any data about how it has changed?
Yes, the data that we have is really anecdotal, and it's also a bit. We can also say that we can see that it hasn't had any negative effects on public safety. There's been no effect on crime that can be traced to electronic monitoring. And from the data that was released from the sheriff's office here in Cook County, there was a very, very, very about 99% of the people at the time that the sheriff released data earlier was that about 99% of people who used the additional movement that was granted used it successfully and without any issue.
And there are always complaints about the revolving door. So for the state's attorney, pressing charges or not pressing charges, that has nothing to do with the Pretrial Fairness Act, just to clarify.
Yeah, there's nothing that is ever stopping the state's attorney or the prosecutors from pressing charges whenever there's any instance of a person being accused or alleged to have committed a crime. Additionally, the Pretrial Fairness Act does not stop anyone from being rearrested and taken back into custody if they are accused of doing something while they're out on pretrial release.
So repeat offenses, repeat offenders, that would be at the judge would handle that.
Yeah, the prosecutors would press charges if there's an accusation of someone doing something while they're out on pretrial release, and then the judge would determine what to do about that case.
Have there been any cases that are similar to that had anything to do with electronic monitoring?
When you say similar to what?
Like the revolving door, and some people maybe recommitting offenses that are jailable. Do you have any information on that? You said mostly everything is working out fine.
Yeah. The data shows that it's going fine, and in any instance where there is an accusation where someone's done anything while they're on pretrial release, there is always the opportunity for the prosecution to bring charges and for the judge to order someone to pretrial detention.
So what about transparency and accuracy of the Pretrial Fairness Act in the future? Are you going to continue to work with the data, or is it going to be shaped if there are flaws in it currently?
Yes, so the Pretrial Fairness Act mandated that there be statewide data collection from all of across the state. So from coming from the top down, from the government, from the I believe this might be run by the Administrative Office of the Illinois Courts or the Illinois Criminal Justice Information Authority. But coming from the government, there is a requirement to collect data about how the pretrial cases are being processed all across the state, so that can be used to inform implementation moving forward.
And there is room for amendments.
Always. With any legislative change, there's always the opportunity to make any amendments during any legislative session.
Mm-hmm. Is there going to be any assessment, any report at a certain period of time after the Pretrial Fairness Act takes into effect?
So the Pretrial Fairness Act does require, as I mentioned, that the state level data is collected. We don't know the report schedule for that, but we do know that it is required for it to be collected and for it to be published. And then we know that at least for our coalition and our statewide network, we will be doing court watching and releasing interim updates and reports over the next few months to a year.
We have 1 minute left or less. Could you give us your information if someone wants to contact you?
Yeah, so people can reach out with any questions about the Pretrial Fairness Act to info@endmoneybond.org.
Thank you so much for joining us.
Absolutely. Thank you for having me.
Bill Morton, President of the Rogers Park Chamber of Commerce, and I am Trudy Leong, Administrator of the Rogers Park Chamber of Commerce. Thank you and this is Brianna Payton. Thank you so much for joining us this afternoon, and see you next week.
My pleasure. Thank you.
Thank you.